Thank you, Mr. Chair, and Attorney Doyle, good to see you.
You too.
Does the division keep any statistics on what percent of cases sentence modifications are sought in?
I do, we may. We have some very good research and data planning people. I do not have any particular knowledge. And your question is not how many are filed, but how many are granted?
No, how many are filed?
Okay. I do believe in the, if I was reading it correctly this morning, in a letter submitted by the Judicial Branch's External Division, they put some numbers in there. I will tell you that in the time that I've been the state's attorney in New Haven since June of 22, they have substantially increased in number, more than 2.5 times.
Okay.
So part of our concern here is that, just to put it in perspective, I've got 400 cases. If we resolve all of those right now, would say please, and let's just assume some of them involve prison sentences, that means double that number. In addition to the regular docket, I'll have twice as many sentence mods 2 years from now.
Okay. I mean, clearly the thought in 1327 is that perhaps 5 years in between modification requests is too long, and I understand your concern that 2 years might be too short. Is there a happy medium? Is it 3 years? Is it 4 years? I mean, one way or the other, the burden is going to be the same, and it's just a question of how often that burden is going to be undertaken.
Well, one fact I'd like to just to point out, Representative, just to recall this, right now, if the sentence is less than 7 years, you could apply for a sentence modification the day after you get sentenced. I just had one of those 2 weeks ago. But if you are sentenced to more than 7 years, okay, you get to, as a plea, you would need the state's permission, okay, as the gatekeeper on that. And I want this body to be aware. In New Haven, I have about 70 of those pending. Once or every 6 weeks, my staff gets together, 5 prosecutors, we review as the gatekeeper function. Some we agree, some we do not. And the ones where I would indicate we don't agree are usually when individuals don't have very much as far as rehabilitative efforts while in custody, or at the very, very beginning, or not even halfway through a large sentence. But there still is a process. So when we get to the 5-year part, just to recall, it's sentences that are greater than the 7 years, which requires permission, or jury trials. So if somebody goes to trial and gets convicted and say on whatever charges is given a 40-year sentence, then it's every 5 years if denied.
Okay.
In addition to all the other statutory methods as well.
Okay. I mean, I think in general I agree with your concerns on 1327. I am struggling, though, on 1502 to see why this would be a tremendous burden. I mean, practicing in the area myself, I mean, obviously, if I think I've got any factors that are going to help my client, you're darn right I'm going to be bringing them up to the state's attorney and or the judge in a supervised pretrial. But you know, I guess having it be a requirement, for lack of a better word, of prosecutor saying to a defense attorney or a pro se, if it happens to be that way, are there any factors we ought to be considering? I mean, I guess I don't see that as being as great of a burden, and I certainly understand that there are far more cases than you have people to adequately handle them.
And in regards to the staffing issues, I mean, you know, I know that's for another committee here, but the reality is we accept that, okay? You know, we know that. And I can tell you as that I personally have some of the most hardworking prosecutors in the state. You know, I just think about the fact that yesterday afternoon, while the St. Patrick's Day parade's going on in New Haven, 3 of us were in the office working on behalf of the people. But I would tell you in regards to 1502, I think the greater concern for us are those factors in regards to sentence modifications as opposed to what Senator Gatker-Wilcox talked about doing it in the first part. I'm more concerned about the sentence modification part, and I know that we're very concerned about the part where it appears to say that if you have been a victim of these matters and you can establish it at sentencing, that there's a whole entirely different sentencing structure for individuals in that position. You folks appoint the Superior Court judges, And I think that's really difficult to say to them, you have discretion, but in certain situations, you're not going to have discretion. So you have discretion, but in certain situations, you have to go there. But that's for this body to determine.
Okay.
Thank you.
Thank you, and appreciate you being here and your insight on this.